Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss case number 73 listed in the list of AOR leading cases. And the case is titled as Kaushal Kishore versus State of Uttar Pradesh and others. It is a 2003 Supreme Court judgment that deals with the scope of Article 19 Clause 1 and Article 19(1)(a), Article 19(2), as well as Article 21. Now, this is a five judges bench decision given by Justice Abdul Nazir, Justice Gawai, Justice Bopanna, Justice Rama Subramanian, and Justice Nagratna. Now, Justice Subramanian is authoring the majority verdict on behalf of Justice Nazir, Justice Gawai, Justice Bopanna, and himself. And Justice Nagratna is sitting in a partial dissent in this judgment. Now, when we come to the facts of this case, now the facts of this case are that there are some statements made by the political leaders. Okay, now what is happening in this case, that one minister in UP who is sitting in a public office, he makes a statement with respect to rape of a woman and her child. Now, that statement that he makes is derogatory in nature, and the then union minister, makes a public statement calling that incident a political conspiracy. A similar instance is also observed in the state of Kerala. And because of these two cases, the petition is reaching before the Supreme Court and under Article 32, alleging that such statements from high-ranking official of the courts, particularly high-ranking officials of the government, particularly the ministers, violated their fundamental right to dignity under Article 21. Now, the petitioners are also raising the question that when a minister, when a public serving minister is making such statements, whether restrictions can be imposed on public functionaries from making derogatory remarks, and whether the state is vicariously liable when such statements are being made. Now, the respondent herein is arguing that, which is state of UP and others. Now, the respondent herein is arguing that state cannot be made personally liable for something which is expressed by its ministers in their personal opinion. And the said minister who made such deliberate remarks, he also contended that the statement he has made in his personal capacity, in his personal opinion, and not as a part of his official duty as the minister. And the basic questions that arises before the court is that how would you balance right to life with dignity under Article 21 and personal liberty, along with Article 19(1)(a), which is the freedom of expression of a public official. Next question arises as whether the state can be held vicariously liable for such statements. Can the freedom of speech of public officials be restricted beyond the limitations that are entailed in Article 19 Clause 2, and whether the court has the power to make some guidelines with respect to restraining public functionaries from making adverse statement in such sensitive matters. Now, the court there is a majority opinion and there is a minority opinion in this case. Now, the arguments that have been raised by the respondent are that the statements have been made in the personal capacity and the state cannot be made thus vicariously liable, whereas petitioners are contending that statement of ministers hurt the dignity and mental peace of the victim's family, and state is constitutionally bound to protect fundamental rights and it should be held responsible. Now, court, in this judgment, there are opinion that have been given by Justice Subramanian, and the majority view, which entails the view of Justice Nazir, Justice Bopanna, Justice Gawai as well. It goes like freedom of speech under Article 19(1)(a). It includes criticism of the government and public affairs, right? That's number one. Public functionaries enjoy equal rights of free speech as they enjoy, as the citizens do enjoy. Now, when when that particular minister is basically calling that incident a political conspiracy, it is basically, you can say that it is a criticism of the existing governmental structure, or it is that it is his own opinion. Because the article 19(1)(a) does not restrict a public functionary to make any personal opinion, make a personal public opinion, right? Now, public functionaries do enjoy equal rights of free speech as as a citizen enjoy, and state cannot be held liable for personal remarks made by public functionary unless it is part of official duty or as endorsed by the state. Now the court basically is saying that if such kind of if such opinion, or if such remark that has been made, if it is made with respect to the duty of the public official, then the state do have some kind of liability. A minister's speech or the public official or public functionary's speech or expression should have a nexus with the official duty for state liability to arise. And constitution, when we read the constitution, when we read about liabilities of the government, constitution does not envisage vicarious liability of the state for every statement made by its functionaries. Otherwise, there are multiple statements that emerge. If we make state liable, that is going to be a very disproportionate attack on the state liability as well. Now, merely holding public office, now just because I am holding the office of a minister, it does not transform a personal or political remark into the act of the state. Now, if a minister is expressing his opinion in the personal capacity, that does not mean that he is representing the state, or his speech is transforming into a political remark, into an act of a state, right? Now the bench is observing that we understand the gravity of the speech that has been made. While it is still unethical, it does not automatically become a constitutional tort attributable to the state. Now, the court herein is saying that minister was part of the government, and but however state cannot be made to bear made to bear vicarious liability. Now justice Nagratna is partially dissenting to the majority view, and she is holding that government can be made vicariously liable by when there is a statement made by a minister, when it is traceable to any affairs of the state or protection of the government by invoking the principle of collective responsibility. While the other judges who are sitting in the majority opinion, including Justice Subramanian, Justice Gawai, Justice Bopanna, and Justice Gawai, Justice Bopanna, and Justice Nazir, they are not, in line with the view that has been taken by Justice Nagratna. Now, another question that comes before the bench in this case is, yes, in this case is, can a public official statement violate the fundamental right to life and liberty of an individual? What is the impact of the statement that has been made under Article 19(1)(a) on Article 21 of for Article 21 of an individual? Now, court herein is basically saying that they are agreeing that a minister's remark are dismissive or derogatory in nature, because the comment was made on a rape victim, and it violated the dignity, mental peace of the family of the victim as well. But the court herein is holding that there should be a direct and proximate connection between the statement and infringement of personal liberty or dignity. Any statement that is made by a public official will not automatically tantamount to constitutional violation under Article 21. Constitutional violation of Article 21. Now, this case, the court are acknowledging that this is an unfortunate and unfortunate case, and but however, it could not be proved that the statement that has been made by the person accused here, the minister accused here, has direct legal injury or deprivation of any fundamental rights. But the court herein is acknowledging that a public official speech can violate Article 21 in exceptional cases, but not every irresponsible or offensive statement would meet that threshold. Now, constitutional remedies cannot be invoked unless you show that an actual and substantive harm has been made. But one observation that the court is making herein is that one observation that the court herein is making the majority judgment is, taking that when we look at AK Gopalan has lost its hold over, the time. We have witnessed the evolution of Article 21 from traversing through Manika and other cases like Justice K.S. Puttuswamy's case. We actually envisage that Article 21 can only be applied to state instrumentalities. But the court herein, the majority judgment herein is holding that a fundamental right under Article 19 or 21 can also be enforced even against persons who are other than state or its instrumentalities. That is what the majority judgment is holding. Now, Justice Subramaniam is authoring that the original thinking that these rights can be enforced only against state has evolved over a period of time. The transformation from state to authorities to instrumentalities of state to agency of the government or to, having a governmental character or enjoying of monopoly or status being conferred by the state to deep and pervasive control and to nature of the duties performed, there has been a transformation. But but when we look at Justice Puttuswamy's judgment, the court herein is referring to Justice Puttuswamy's judgment, which we have also done at number 48 in the list of AOR leading cases. It is holding that the right to privacy was recognized as a right which protects the inner sphere of the individual from interference by both the state and non-state actors, and therefore relying on the judgment that has been given in Justice Puttuswamy case, the right to privacy case, the five judges bench the majority in the five judges bench, which are the four judges, they are also holding that state is also under a duty to affirmatively protect Article 21 rights of a person against any threat to their personal liberty or dignity, even if such threat is originating from a non-state actor. Now, but however, to invoke the constitutional remedies, the court again, we come to the same point, because in this case, the court could not form any nexus, any direct nexus that, some legal injury or deprivation of fundamental rights can be shown. So in this case, the court did not find it, but then court is holding, majority verdict is holding that Article 19 and Article 21 violation can be challenged even if they are, done by the non-state actors as well. So the court herein is expanding horizontal application of the fundamental rights and not just limiting it merely to the vertical application. But however, Justice Nagaratna, of course, because she is sitting in the dissent, she is also taking a different stand with respect to horizontal application of Part 3 of the Constitution, especially Article 19 and 21, which is being discussed in this case. She basically says that there is a practical difficulty, okay, there is a practical impediment when allow such constitutional fundamental rights to operate against private individuals, private entities as well, because it could be permitted only if, there is a difference between a fundamental right and a common law right, the incidence of a duty to respect each of such form of right and forum which could be called upon to adjudicate on the failure to respect each of such rights is ignored. According to, the dissenting judge, Justice Nagaratna, court is basically, she's basically noting that Article 12 has taken an evolution. But again, the scope of Part 3 does not navigate beyond state. It navigate beyond state, and a private part and a private body acting in private capacity fulfilling a private function cannot be made amenable to the claims of fundamental right violation, right? So now however, she is sitting in a partial dissent. She is basically saying that the rights in the realm of common law, which may be similar or identical to in their content to the fundamental rights under Article 19 or 21, operate horizontally. However, the fundamental rights under Article 19 and 21 may not be justiciable horizontally before the Constitutional Court, except for those which have been statutorily recognized and in accordance with the applicable law. So there may be basis for seeking such common law remedies as well. Now, she is not aligning with the position that is taken by the majority bench on horizontal application, majority judgment on horizontal application of the fundamental rights in this judgment. And when we come to another issue that can, by the judgment, by, using judicial prudence, can freedom of speech of public functionaries, can it be curtailed beyond what is prescribed by the constitution in article 19 clause 2? The court is answering it in negative, holding that public officials, ministers, they enjoy the same fundamental rights as citizens, which includes freedom of expression under article 19(1)(a), subject to reasonable restrictions given under article 19 clause 2. And Article 19, Clause 2 are the exhaustive grounds which restrict the right of expression guaranteed under Article 19(1)(a). Now, the court is saying that we cannot introduce new grounds of restriction. Just a second. The court is basically saying that we cannot, introduce new grounds of restriction. For example, collective responsibility, public accountability, ministerial responsibility, etc. Because these grounds are exhaustive. They are, made by the constitutional forefathers envisaging something, and the courts cannot read into new, restrictions, even when the court has a noble intent. Now, Justice Nagratna, of course, is agreeing to it. She is writing a partly concurring, partly dissenting opinion. She is emphasizing that there is an ethical obligation of public official to maintain restraint, and but however, she does not, make a call for having a new legal restrictions on it. Now, whether courts can make some guidelines, court can bring out some rules. The court is saying that if it is a legislative gap which they cannot, legislate upon, and if they do so, there will be judicial overreach, right? So now when we look at, now this judgment is seemingly interesting because one, it is the most recent judgment, but now when we look at, the notion that if court comes with making some kind of regulation, making some kind of gap filling legislation or regulate procedure, or laying down some rules, some guidelines, there are various terms that court has been taking time and again. For some cases, the court deny in the name of judicial overreach, while in some cases there is an activism exhibited by the courts with respect to making such guidelines. But however, this jurisdiction under Article 42 and Article 32 is subjective to, the need that arises before the bench, and in this case the court is not finding it enough sufficient case to, issue some guidelines in the ends of justice in exercise of Article 32 or Article 220 to Article 142 of the Constitution of India. So therefore, these were the findings that were held in the case of Kaushal Kishore versus State of Uttar Pradesh. And I hope the discussion is useful. For more such videos, please stay tuned with us on Legal Darshan. Keep watching, keep subscribing, keep liking the channel. Thank you, everyone. Have a nice day.